Greetings from Vienna. I am Yao Chenggong, legal officer at the Secretariat of the United Nations Commission on International Trade Law, or UNCITRAL for short. For those who are not familiar with UNCITRAL, UNCITRAL is a core legal body of the United Nations system in the field of international trade law. For over 50 years, UNCITRAL has been working to modernize and harmonize the rules of international commercial activities. Today, I will talk about the UNCITRAL texts on transparency in the context of treaty-based investor-state arbitration and the repository of published information created under them. These texts and the repository together constitute the UNCITRAL Transparency Standards. It is no coincidence that the theme is chosen for 2024 because the year 2024 marks the 10th anniversary of the adoption of the UNCITRAL Transparency Standards. In my presentation, I will discuss when, why, and how the UNCITRAL Transparency Standards were developed, as well as their content. Presentations by my colleagues on the same topic are available in other 5 United Nations languages. In order to carry out its mandate, UNCITRAL has created a complete framework to solve disputes through international arbitration. On this slide, you can see the main UNCITRAL texts adopted so far in the field of international arbitration. In the first row of this list is a convention on the recognition and enforcement of foreign arbitral awards. In short, we call it the New York Convention. This convention was adopted in 1958 prior to the establishment of UNCITRAL, but served as the basis for UNCITRAL's legislative work in this area. The New York Convention is one of the most important United Nations treaties in the area of international trade law and also the cornerstone of the international arbitration system. Recognizing the growing importance of international arbitration as a means of settling international commercial disputes, the New York Convention seeks to provide common legislative standards for the recognition of arbitration agreements and courts' recognition and enforcement of foreign and non-domestic arbitral awards. The New York Convention serves in creating a favorable environment for dispute settlement by arbitration through the development of a complete and harmonized framework that enables the disputing parties to use arbitration as a flexible and efficient means of dispute settlement. The UNCITRAL arbitration rules do not require the enactment of domestic legislation or being part of a convention to be used. Instead, the UNCITRAL arbitration rules are contractual instruments ready to be used by parties if they so agree. The application of the UNCITRAL arbitration rules is a result of party autonomy principle. This has had an impact on the flexible nature of the rules, which accommodates where permissible the disputing party's choice of the conduct of the arbitral proceedings. The UNCITRAL arbitration rules in its various versions are generic and are applied generally regardless of the parties involved, whether it's states or private parties, and also the instrument invoked, whether treaty or contract. Accordingly, the rules could be used for both commercial and investment disputes. But in contrast, the rules on transparency apply specifically to investor-state arbitration under an investment treaty. And for the purpose of the rules on transparency, a treaty shall be understood broadly as encompassing any bilateral or multilateral treaty that contains provisions on the protection of investments or investors and a right for investors to resort to arbitration against parties to the treaty. This includes any treaty commonly referred to as a Free Trade Agreement, FTA, Economic Integration Agreement, trade and investment framework, or a cooperation agreement, or a bilateral investment treaty. We will now focus on the transparency standards in treaty-based investor-state arbitration. The UNCITRAL Transparency standards refer to three components. The first component is the rules. The UNCITRAL rules on transparency in treaty-based investor-state arbitration comprise a set of procedural rules that provides for transparency and accessibility of the public to treaty-based investor-state arbitration. The second component is a convention. The United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, also called the Mauritius Convention on Transparency, is a multilateral instrument by which contracting parties with investment treaties concluded before April 1st, 2014 express their consent to apply the rules on transparency. And this convention entered into force on October 18, 2017. The third component is a repository. The repository of published information was established and envisaged under Article 8 of the Rules on Transparency. Pursuant to the General Assembly Resolution 68/106 of December 16, 2013, the UNCITRAL Secretariat, on behalf of the Secretary General of the United Nations, fulfills the role as the repository. The specificity of investor-state arbitration emanates from the parties involved, a state and an investor, as well as the subject matter of the dispute having an impact on the public interest. In the framework of such disputes, an investor can sue a host state for breaches of its obligations as enshrined in a legal instrument, for example, a bilateral investment treaty or a multilateral investment treaty. Investment disputes always affect public interests. They are directly related to the state's investment policy, in particular to attract foreign investment as a means of ensuring long-term sustainable development and economic growth. In addition to general development policy and investment climate issues, such disputes often involve specific legislations such as environmental, health, and natural resource legislations. Furthermore, the interests of certain groups of people or areas where investments have been or are being made may be directly or indirectly affected by such disputes, such as the rights and interests of owners or users of the land or other property involved in investment projects, the rights and interests of users of service such as electricity and gas provided or financed by the investor. The public at large or such affected persons may be interested in receiving timely information about the existence of such dispute, allegations of wrongdoing, other legal issues arising from the dispute, arguments made by the respondent, procedural or interim orders, and the final award in order to be able to protect their rights and interests in a timely manner. Meanwhile, investment disputes usually affect the interests of taxpayer of the respondent to the dispute. It is no secret that arbitration costs money. In addition to the cost of representing the state in arbitration, the arbitral award may result in the need to pay damages or compensation to the investor if the respondent is held liable by the arbitral tribunal. Therefore, the lack of transparency in resolving this type of dispute was perceived as contrary to the fundamental principles of good governance and human rights upon which the United Nations is founded. The General Assembly, in its 68th plenary meeting, recognized the need for provisions on transparency in the settlement of such treaty-based investor-state arbitrations to take account of the public interest involved in such arbitrations. Also, as the rules on transparency apply to treaty-based ISDS, the report of the UNCITRAL Working Group 2 at its 53rd session mentioned that enhancing transparency in treaty-based investor-state arbitration should be considered in the context of foreign direct investment. And it is considered a tool for the long-term sustainable growth of developing countries, including sustainable economic growth through the increase in domestic demand and domestic employment. Now we turn to transparency reform. Generally speaking, the transparency reform was done in 2 steps. Prior to the adoption of the rules on transparency, there was a lack of harmonization on transparency, especially in case where, first, there was no provision on confidentiality in the investment treaty, second, no agreement by disputing parties on confidentiality or transparency, and third, there's no clear arbitral rules on this issue. This has led to the arbitral tribunal exercising its discretion. Accordingly, harmonization and developing good practices on enhancing transparency were adversely affected. Moreover, such lack of transparency was perceived as contrary to the fundamental principles of good governance and human rights upon which the United Nations is founded. This lack of general standard on transparency was a major concern due to the impact of ISDS on public interest. The transparency standards aimed to address the concerns previously mentioned. To achieve this, UNCITRAL negotiated the main components of the standards step by step. The first step is the rules on transparency, including the repository, adopted in 2013 and came into effect on April 1st, 2014. The second step is the adoption of the Mauritius Convention on Transparency in 2014. Before the rules on transparency was introduced, there are conditions that need to be met in order for an arbitral award to be made public pursuant to the old versions of the UNCITRAL arbitration rules. According to Article 34, Paragraph 5 of the UNCITRAL arbitration rules, transparency could be attained in case there is a consent of all parties to make the award public, or where there is a legal duty of disclosure. Such a standing point served the purposes for commercial arbitration, but for ISDS, further enhancement of transparency was needed. Now we turn to the content of the rules on transparency. The rules are a set of procedural rules that could be applied alone or in conjunction with any arbitration rules, not necessarily the UNCITRAL arbitration rules. In case of conflict between the rules on transparency and the applicable arbitration rules, the rules on transparency shall prevail. The rules are a balanced text that takes into account both the public interest in such arbitrations and the disputing party's interest in a fair and efficient resolution of the dispute. For example, the rules take into account that confidential or protected information shall not be made available to the public. The rules also take into account that full or premature publicity may jeopardize the integrity of the arbitral process, for example, when it could hamper the collection or production of evidence, lead to intimidation of witnesses, lawyers acting for the disputing parties, or members of the arbitral tribunal. The rules further ensure legal certainty by providing that, notwithstanding any provision in the rules, where there is a conflict between the rules on transparency and a treaty, the provisions of the treaty shall prevail. Where any of the rules is in conflict with a provision of the law applicable to the arbitration from which the disputing parties cannot derogate, the provision of the law shall prevail. The rules on transparency harmonize the procedure for enhancing transparency in arbitral proceedings and reflect the best practices in this area. The main concepts of the rules on transparency are obligation of disputing parties to apply and comply with the rules. If the rules apply following their inclusion into an investment treaty, the disputing parties must apply the rules and cannot derogate from them unless the investment treaty permits them to do so. Fostering transparency and maintaining sufficient flexibility to the disputing parties without creating delays, increasing costs, or unduly burdening the arbitral proceedings. And lastly, any limitation on transparency should not defeat its very purpose with regard to good governance. The concept of the rules is based on two principles: increased openness to the arbitral proceedings and increased participation in the arbitral proceedings. Together, they lead to the increased transparency. Increasing the openness of arbitral proceedings is achieved by publishing information at the commencement of arbitration proceedings, by publishing documents during the proceedings, and by holding generally open hearings. Increased participation in arbitral proceedings is achieved by expanding the scope of persons who may submit written submission to the arbitral tribunal. The rules provide sufficient flexibility on a case-by-case basis depending on the circumstances of the case for both the arbitral tribunal and the disputing parties to avoid delays, increased costs, or undue burden on the arbitral proceedings. In particular, the arbitral tribunal has a discretionary authority, for example, to take appropriate measures to restrain or delay the publication of information where such publication would jeopardize the integrity of the arbitral process. And in addition to such discretions under Article 1.3, paragraph B, the arbitral tribunal has a power to adapt the requirements of any specific provisions of the rules to the particular circumstances of the case, after consultation with the disputing party, if such adaptation is necessary for the conduct of the arbitration. But in the presence of any conduct, measure, or other action having the effect of wholly undermining the transparency objective of these rules, the arbitration tribunal should ensure that those objectives prevail. Pursuant to Article 3, the following shall be made public: the notice of arbitration, the response to the notice of arbitration, the statement of claim, the statement of defense, and any further written statement or written submissions of any disputing party, a table listing all exhibits to the aforesaid documents and to expert reports and witness statements, if such table has been prepared for the proceedings, any written submissions of non-disputing party to the treaty and by third persons, transcripts of hearings where available, and orders and decisions and awards of the arbitral tribunal. Expert reports and witness statements shall be made public at the request of any person submitted to the arbitral tribunal, even if that person is not a party to the proceedings or a third party involved in them. Specific rules are provided for access to exhibits and any other documents that are not subject to public disclosure. The arbitral tribunal may decide on its own initiative or upon request from any persons and after consultation with the disputing parties, decide on whether and how to make available such documents, for example, making them available at a specific site. There are exceptions to this, which will be discussed later. How and when information and documents are made public depends on their nature and the stage of the process. For example, under Article 2, upon receipt of the notice of arbitration by the respondent, each disputing party shall promptly communicate a copy of the notice of arbitration to the repository. Documents to be made available to the public shall be communicated by the arbitral tribunal to the repository as soon as possible. Documents to which special access is granted may be sent by the arbitral tribunal to the repository referred to in Article 8 as they become available and, if applicable, in redacted form. Upon receipt of the notice of arbitration from the respondent, or upon receipt of the notice of arbitration and a record of its transmission to the respondent, the repository shall promptly make available to the public information regarding the names of the disputing parties, the economic sector involved, and the treaties under which the claim is being made. The repository shall make all documents available in a timely manner, in the form and in the language in which it receives them. According to the rules, hearings for the presentation of evidence or for oral arguments shall be public by default, and such public hearings may be provided through video links. There are also exceptions to this rule. All transparency provisions shall be subject to necessary exceptions. In particular, exceptions must be made for confidential or protected information or to ensure the integrity of the arbitral process. The rules provide for the exclusion or redaction of such information and that some or all hearings may be held in private if necessary to protect confidential information or the integrity of the arbitral process. In addition, nothing in the rules requires the respondent state to make public information the disclosure of which is considered to be contrary to their essential security interests. Other provisions of the rules are also applicable, such as exceptions for logistical reasons. In addition, the discretionary authority rendered to the arbitral tribunal, as well as provisions that refer to binding provisions of applicable law or a treaty authorizing parties to derogate from the rules, are also applicable. It should be noted that participation in the arbitral proceedings is generally granted only to the parties to the dispute, but because of the nature of investment arbitration proceedings, the arbitral tribunal may allow third persons or party to an investment treaty who are not parties to the dispute to make submissions to the arbitral tribunal. In deciding whether to allow a third person to make a submission, the arbitral tribunal shall first consult with the parties, and second, it may consider various factors, including whether the third person has a significant interest in the arbitration and the extent to which making such a submission would assist the arbitral tribunal in resolving a factual or legal issue involved in the arbitration by bringing a perspective, special knowledge, or insight different from that of the disputing parties. The arbitral tribunal must ensure that such submission by a third person does not disrupt or unduly burden the arbitral proceedings or unfairly prejudice the interests of any of the disputing parties. And moreover, the arbitral tribunal shall afford the disputing parties a reasonable opportunity to present their observations on any submission made by such third person. Similar rules apply to the submission of a non-disputing party to an investment treaty. It is recognized that such a party to a treaty may also play a significant role in the interpretation of the treaty. However, the rules caution against using such submissions as a format of diplomatic protection. Diplomatic protection refers to the diplomatic efforts made by a state on behalf of its nationals who are facing harm or mistreatment in a foreign country. It is widely accepted that in contemporary international law, the protection of the rights of companies and the rights of their shareholders and the settlement of the associated disputes are essentially governed by bilateral or multilateral agreements for the protection of foreign investments and not by diplomatic protection. Pursuant to Article 1, Paragraph 1, the rules on transparency apply automatically to investor-state arbitrations initiated under UNCITRAL arbitration rules pursuant to a treaty providing for the protection of investments or investors concluded on or after April 1, 2014, unless otherwise agreed by the parties to the treaty. Thus, if the parties apply in accordance with the provisions of an investment treaty, the disputing parties must apply the rules and may not derogate from them, except as authorized by the investment treaty. In accordance with Article 1, Paragraph 2, with respect to investor-state arbitrations initiated under the arbitration rules of UNCITRAL pursuant to a treaty concluded before April 1, 2014, the rules apply only if the disputing parties agree to their application with respect to that arbitration, or the parties to the treaty, or in the case of a multilateral treaty, the claimant states and the respondent state have agreed after April 1, 2014 to the application. In other words, the disputing parties to an investment state treaty-based arbitration may agree to use the rules on transparency even if not provided in the investment treaty under which the arbitration is initiated. Moving from the first step, which is the rules on transparency, we now shed light on the second step of enhancing transparency, which is a Transparency Convention. The United Nations Convention on Transparency in Treaty-Based Investor-State Arbitration, in short, the Mauritius Convention on Transparency, supplements existing investment treaties with respect to transparency-related obligations. States and regional economic integration organizations acceding to this convention agree to apply the rules on transparency in the context of treaty-based investor-state arbitration that they concluded before April 1, 2014, whether or not it's initiated under the UNCITRAL arbitration rules. However, parties to investment treaties may exclude the application of the rules on transparency by means of a reservation. The rule of bilateral or multilateral application of the Convention, and thus the rules on transparency, is provided for in Article 2, Paragraph 1 of this Convention. The Convention applies if the respondent is a party to the Convention, the claimant is from a state that is a party, and those states have not formulated reservations. Paragraph 2 of the same article refers to a unilateral offer to apply the rules on transparency when only the respondent is a party to the convention and that party has not made a reservation to unilateral application, and the claimant, although originating from a state that is not a party to the convention, agrees to apply the rules on transparency. Accordingly, the Convention is an effective mechanism for giving effect to the rules on transparency without the need to amend the existing 3,000 international treaties concluded before April 1, 2014. At the same time, a party to the Convention may exclude from the scope of application of the Convention and consequently the rules on transparency investment arbitrations under a specific investment treaty concluded before April 1, 2014, or make a reservation of arbitrations conducted under a specific set of arbitration rules or procedures other than the UNCITRAL arbitration rules and in which it is a respondent. In accordance with Article 3, Paragraph 1 of the Convention, when formulating such a reservation of a specific investment treaty, the party could do so by identifying the title and name of the contracting parties to that investment treaty. A party may also declare that the unilateral offer of application shall not apply to investor-state arbitration in which it is a respondent. To date, the Mauritius Convention has 24 signatories. In particular, the European Union signed the convention on July 2, 2024 in New York. 9 states are parties to the convention, including Australia, Benin, Bolivia, Cameroon, Canada, Gambia, Iraq, Mauritius, and Switzerland. Those states became parties to the convention without making any reservations. As noted in paragraph 2 of the General Assembly Resolution 70/115, the repository of published information constituted a central feature both of the Rules on Transparency and the Mauritius Convention on Transparency by providing a consolidated, transparent, and easily accessible global case record database for all investor-state arbitrations conducted pursuant to the Rules on Transparency and the Convention. The repository makes available for public access information on treaty-based investor-state documents and arbitrations conducted also under other arbitration rules with transparency elements similar to the UNCITRAL Rules on Transparency. The link to access the repository is reproduced on this slide. This consolidated global database of cases and related documents is easily accessible to the public and free of charge. Currently, the design of the repository is only in English at the moment, and case materials are available in the languages in which the materials were sent to the repository without translation. The operation of the repository relies entirely on voluntary contributions, with the European Union being the main donor since 2016. Information published in the repository includes case files, decisions, awards, and other information that may help you explain the outcome of the proceedings. As shown on this slide, by June 2024, 28 cases involving 15 respondents have been published. As a review of the application of the Rules on Transparency provided by the UNCITRAL Secretariat to the Commission annually shows that there is a tendency towards more transparency in investor-state dispute settlement. According to the review provided to the Commission in 2024, the Rules on Transparency apply to 193 international investment agreements, as well as to disputes under a further 245 international investment agreements to which parties to the Convention are parties, where the claimant agrees the application of the Rules on Transparency. More than 120 agreements have provided for the application of the rules by reference to the UNCITRAL arbitration rules, and some of them have additional transparency provisions for the application of other arbitration rules. In addition, some international investment agreements that exclude the application of the Rules on Transparency nevertheless included some elements of transparency in other provisions. This chart shows the transparency trends in international investment agreements concluded since April 1, 2014. As you can see, both the deep blue and the green parts refer to treaties concluded since April 2014 that refer to the UNCITRAL arbitration rules in general, or specifically to UNCITRAL arbitration rules, the 2013 version. And the latter refers to the version that have included the Rules on Transparency. The green part is further labeled with a plus to highlight that it refers to treaties concluded since April 2014, not only give reference to the UNCITRAL arbitration rules, but also contain additional treaty provisions on transparency in arbitral proceedings, in case other arbitration rules may apply. Accordingly, this chart shows that there is a tendency towards more transparency in investor-state dispute settlement. It is also worth mentioning that the information in this chart is annually updated and available in the status paper submitted to the Commission. For 2024, please refer to the A/CN.9/1172 dated April 19, 2014 in its paragraph 16. The transparency standards was the first successful endeavor to reform the investor-state dispute settlement and paved the way for further work on ISDS reform conducted by UNCITRAL. Such reform can be achieved while maintaining the efficiency, legitimacy, and effectiveness in the system. In terms of efficiency, the transparency standards can be put into effect without the need to amend the 3,000 existing bilateral investment treaties. Moreover, there is a flexibility in its application, as the states can formulate reservation. Furthermore, the transparency provisions do not jeopardize confidentiality. With regard to legitimacy, the lack of transparency has posed concerns regarding ISDS. The introduction of UNCITRAL transparency standards has caused the public perception of ISDS to be more favorable, and furthermore, it allowed matters of public interest to be addressed more openly and reinforce public trust in the system. As for effectiveness, the enhancement of transparency is appealing to investors and stimulates foreign direct investment to the host countries. Furthermore, it promotes good governance practices as well as being an important indicator of a democratic process. Also, the transparency standard is a means to put the Sustainable Development Goals into effect. SDGs are a universal call to an action to end poverty, protect the planet, and improve the lives and prospects of everyone everywhere. SDG Goal 16 deals with peace, justice, and strong institutions. The transparency standards is a means to ensure the attainment of Goal 16 by promoting public access to information. In view of the above, the UNCITRAL Secretariat is working to enhance the understanding of the objectives of the transparency standards and to make information and documents on arbitration proceedings available to the repository timely in accordance with the Rules on Transparency, Article 8. UNCITRAL transparency standards were an early contribution to ISDS reform, but definitely not the last one. As you may already know, UNCITRAL Working Group 3 has been working on investor-state dispute settlement reform since 2017. The outcome of this working group's work has led to the adoption of a series of UNCITRAL texts in 2023, including model provisions and guidelines on mediation for international investment disputes, and codes of conduct for judges and arbitrators in international investment dispute resolution. Additional UNCITRAL texts in this area are expected to be adopted in 2024 and the years to come. As we have shared before, the year of 2024 marks the 10th anniversary of the UNCITRAL transparency standards. A series of memorizing and celebrating events have been planned throughout the year by the UNCITRAL Secretariat in collaboration with interested stakeholders. More information will be published on the events and news on the UNCITRAL website as well as our social media accounts. This concludes my presentation. Thank you very much for your attention, and I wish to invite you to visit the UNCITRAL website. Our website is available in all 6 UN languages, and you may find more information about the transparency standards as well as other texts and areas of work by UNCITRAL.